It's 9 minutes after 5 o'clock on the 2nd of August 2021. Let us turn to this historical record. The topic is concerning criminal law in the preservation of public order. Section F, insanity. What, under the Soviet system, were the considerations of insanity in regards to public order? Just see. Insanity. Case of Toshin. Bulletin Verkhovnego Suda RSS FSR 1971, number 4, page 16. The Vologod Provincial Court terminated proceedings in the criminal prosecution of Toshin under RSFSR Criminal Code Article 102 B and H, intentional homicide of two or more with hooligan motives, and Article 206, Part 2, malicious hooliganism, and ordered that he be treated in a psychiatric hospital of a special type. The case was remanded for new trial by the RSFSR Supreme Court's Judicial Division for Criminal Cases on the victim's personal appeal for the following reasons. The provincial court's ruling violated the requirements of the RSFSR Code of Criminal Procedure Article 410 and RSFSR Criminal Code Articles 58 and 59. Under Article 410, when a court finds that a socially dangerous act has been committed by a person who is in an irresponsible condition, it shall issue a ruling not to hold the person guilty, but to free him from criminal responsibility in accordance with RSFSR Criminal Code Article 11. Non-imputability, because the accused cannot realize the significance of his actions or control them because of a chronic mental illness, temporary mental derangement, mental deficiency, or other condition of illness. The court did say in its ruling that Toshin's guilt in committing homicide in a manner dangerous to the lives of many persons, in attempting to kill two or more persons, and in committing malicious hooligan acts was fully confirmed by the evidence submitted, but that in view of the fact that Toshin was held to be irresponsible, the proceedings were terminated, and he was sent for compulsory treatment to a psychiatric hospital of a special type. Yet, in sending Toshin for compulsory treatment, the court at the same time terminated proceedings in his case. That was incorrect. With regard to persons who have committed a crime in an irresponsible condition, the proceedings may be terminated under RSFSR Code of Criminal Procedure Article 410 only if the person, because of the character of the acts committed and the conditions of his disease, does not represent a social danger and needs no compulsory treatment. Toshin committed a serious crime and, as is evident from the expert psychiatrist's conclusion, needs compulsory treatment in a psychiatric hospital of a special type. Under such circumstances, the court was required, in conformity with RSFSR Criminal Code Articles 58 and 59, commitment to a psychiatric hospital, to settle in its ruling the question of the type of psychiatric hospital to which Toshin must be sent for compulsory treatment. That's one case. There's another. Case of Ekimov, Bulletin Verkhovnego Suda SSSR 1973, number 3, page 25. Ekimov was convicted by the Altai Territorial Court on March 10, 1970, under RSFSR Criminal Code Article 171, Paragraph 2, exceeding authority if accompanied by use of a weapon, to 6 years deprivation of freedom, and under Articles 15 and 102, Paragraph E, attempted homicide committed in a manner dangerous to many persons, and sentenced for all his crimes to 8 years deprivation of freedom in a correctional labor colony of severe regime. The penalty was later reduced to 4 years by the RSFSR Supreme Court's Presidium. Oh, apparently the case continues. There's a question. Homicide implies intent to kill. If somebody's been put into a situation where they are put into a frame of reference where they are supposed to complete actions, and in the completion of those actions it has the result of somebody else's death, then you have to establish that they had intent and motive to engage in such actions before you can use the end results as a justification for whatever means you engage to attempt to have them identified in any manner, including as a criminal, but especially including as insane. On the other hand, if one is in a position where they have a particular kind of responsibility, including social responsibility, and they intentionally engage in actions with the intent to debilitate people, including a number of people, with an understanding the end result just might be their death. Would you consider a cell phone a weapon? Let me ask you a question. Would you consider a cell phone in the hands of somebody who had already received professional training on psychology and psychiatry, and also had at their disposal substantial medical information about the effects of radio frequency on somebody's biophysiology, including in manners that could impact their state of mind, including through, shall we say, an academic or professional consideration of, I don't know, a program that had been previously authorized by the Department of State, and then they engage in actions that serve to try to exacerbate people or incite them, including subliminally, to acts of violence, including fatal violence. Can it be said that they engaged in use of a weapon with the intent to commit homicide, including homicide of many people? What would that 8-year term in a penal colony be? And especially insofar as it was reduced to 4. I hope that somebody did not try to make somebody else bear out their punishment in their stead, comparable to the way that people during the Civil War in the United States tried to get somebody else to serve in their place, and then after the war, when they were obligated to debt for losing and agreeing to support the establishment and practice of slavery, were supposed to pay. See, there's a different burden of proof, I contend. If you say you want acknowledgement for that professional consideration, then you also have to be responsible